A Supreme Court ruling just came down with a unanimous 9-2-0 decision that nobody saw coming. And it is about to change everything you thought you knew about your gun rights and what police can do during a traffic stop. If you own a firearm and drive a car, what I am about to tell you in the next few minutes could be the difference between driving away free or standing on the side of the road in handcuffs, wondering how everything escalated so fast. Before we get into it, do one quick thing right now. Make sure you are subscribed. Most gun owners never hear about major rulings like this one until months later, or worse, until they are learning about it from a police officer at their car window. I do not want you to be that person. Stay ahead of it. Now let us talk about what just happened. The case that triggered this unanimous decision revolves around a constitutional tension that has been building for years. On paper, both rights involved are crystal clear. The Second Amendment protects your right to keep and bear arms. The Fourth Amendment protects you from unreasonable searches and seizures. Two separate guarantees, two foundational liberties. But what happens when those two rights collide during a routine traffic stop? For years, courts across the country wrestled with a simple but explosive question. If an officer knows you have a gun in your car, even a perfectly legal one, does that automatically justify searching your vehicle without a warrant? Some lower courts were actually leaning toward yes, and that is where things became genuinely dangerous for every law-abiding gun owner in this country. Because think about what that actually means. If simply exercising your constitutional right to carry a firearm automatically reduced your Fourth Amendment protections, then one right would effectively cancel out the other. You would have to choose between being armed and being secure from warrantless searches. That is not how constitutional rights are supposed to work. That is not what the founders intended. And that is exactly the conflict this case forced the Supreme Court to resolve. The case that reached the High Court started the way most of these cases start, with a routine stop. Imagine you're driving home. Maybe you have your concealed carry piece on your hip, or your range bag is sitting in the back seat. You get pulled over for something minor, a tail light, maybe 5 miles over the limit. In the case before the court, the officer approached the vehicle and discovered during the interaction that the driver had a firearm. The driver was cooperative. He was not reaching for it. He was not acting erratic. He was calm and respectful. But the officer used that gun as a golden ticket. He claimed that because a weapon was present, he had an automatic right to search the entire vehicle without a warrant. No probable cause of a crime, no additional suspicious behavior, just the gun itself. And here is the part that should shock you. The lower courts actually agreed with the police. They ruled that when you have a firearm in your vehicle, even a legal one, that alone gives officers the right to conduct a full search. Think about the gravity of that ruling. Your Second Amendment right to own a gun would effectively cancel out your Fourth Amendment right to privacy. Then it went to the Supreme Court of the United States, and what happened next sent shockwaves through the legal community. All 9 justices, from the most conservative to the most liberal, looked at this situation and said, no. This was not a 5-2-4 split. This was not a partisan argument. It was a 9-2-0 shutout. And that alone should tell you how significant this ruling actually is. Here is the core of what the court said. The mere presence of a legally possessed firearm in a vehicle does not by itself create probable cause to search that vehicle. Let that sink in for a moment. Legal gun ownership is not suspicious activity. Carrying lawfully is not evidence of a crime, and police cannot treat it as such. The justices were very clear. You cannot be punished or treated as a criminal suspect simply for doing something the Constitution explicitly protects. The court told law enforcement directly, You cannot use a citizen's exercise of one constitutional right as justification to strip them of another. 9-0. No dissents, no partial disagreements, no ideological divide. When all 9 justices agree on something touching firearms and search authority, it signals that the constitutional boundary is not ambiguous. It signals clarity at the highest possible legal level. Now I want to slow this down and explain why this matters so much for you personally. During a traffic stop, officers already have certain powers. Courts have previously ruled that officers can order drivers out of their vehicles for safety reasons. That has been established law for decades. But searching your car is a completely different legal threshold. Under the Fourth Amendment, a warrantless search generally requires one of 2 things: either a warrant or probable cause. Probable cause means the officer has specific articulable facts suggesting a crime is being committed. Not a hunch, not a possibility, not a just-in-case feeling. For a long time, some departments treated the mere presence of a firearm as automatically raising safety concerns high enough to justify broader searches. The reasoning went like this: guns can be dangerous. Therefore, if there is a gun in the car, I need to search the vehicle to ensure officer safety. But here is the problem with that logic. Millions of Americans legally carry firearms every single day. In many states, constitutional carry laws allow adults to carry without a permit at all. If lawful gun ownership automatically triggered search authority, then a massive portion of law-abiding citizens would effectively lose their Fourth Amendment protections the moment they exercised their Second Amendment rights. That is exactly the constitutional conflict the Supreme Court addressed, and the court shut it down. Now here's where this gets very real for you. Imagine you are pulled over for a broken taillight. The officer approaches, asks for license and registration, then asks whether you have any weapons in the vehicle. In many states, you are required to inform the officer if you are carrying. In others, you are not required, but may choose to disclose. You answer honestly. Yes, officer, I have a legally carried firearm in the glove box before this ruling. In some jurisdictions, that answer alone could escalate the stop. Officers would use it to justify a full vehicle search. After this 9-0 decision, that justification no longer stands on its own. The presence of a legal firearm does not equal probable cause. That distinction is massive, and it changes the legal landscape for every gun owner who drives a car. But now I need to be very direct with you about something. This ruling does not create a magic shield. It does not instantly shut down every questionable police practice across the country. Court rulings set legal standards, but how those standards apply depends on specific facts in specific situations, and that is exactly where things can still go sideways if you are not careful. The court ruled that a legally possessed firearm by itself does not create probable cause, but the key phrase there is by itself. The moment other factors enter the picture, the entire analysis changes. Let me give you a few real-world examples, so this is completely clear. First, prohibited persons. If you are legally barred from possessing firearms due to a felony conviction, a domestic violence restraining order, or any other disqualifying factor, and an officer has reason to believe that applies to you, then the presence of a gun is no longer innocent. It becomes potential evidence of a crime. This ruling does not protect unlawful possession. It never did. Second, visible violations. If a firearm is in plain view and your state restricts how it must be stored in a vehicle, requiring it to be secured, unloaded, or in a locked container, and you are clearly violating that requirement, the officer now has articulable facts suggesting a criminal violation. Again, the gun alone is not the issue. The unlawful manner of possession is what creates the problem. Third, additional suspicious behavior. If you are pulled over, and in addition to disclosing a firearm, the officer observes drug paraphernalia in plain view, detects the smell of illegal substances, notices contradictory statements, or sees attempts to conceal items, then the firearm becomes part of a broader picture. The court made clear that legal gun ownership is not suspicious activity, but it did not eliminate the automobile exception to the Fourth Amendment. That exception still exists. Under it, officers can search a vehicle without a warrant if they have probable cause to believe evidence of a crime is present. The Supreme Court did not abolish that doctrine. It clarified it. A legal gun is not probable cause, but other independent evidence of a crime still can be. Now let us talk about something else that rarely gets discussed. Even with this 920 ruling, there is a massive gap between the law on the books and the law on the street. Supreme Court decisions do not instantly reprogram every officer in every department across the country. Training takes time. Culture changes slowly. And in the meantime, you are the one standing on the shoulder of a highway, dealing with the reality in front of you, not the ideal version of how things are supposed to work. That gap is real, and ignoring it is dangerous. Imagine you have been calm and respectful. You have clearly stated you do not consent to a search. You have kept your hands visible on the steering wheel, but the officer says he smells something, or he says he is searching for his safety anyway. This is the moment that determines everything. Not your knowledge of the ruling, but your response to that moment. Do not resist. This is the single biggest mistake gun owners make. If you physically try to stop an officer from entering your vehicle, you are moving from a constitutional argument to a resisting arrest charge. You will not win that fight on the shoulder of a highway. You win it in a courtroom. By staying calm, stating your lack of consent clearly, and not interfering, you are creating the record your attorney needs. You are letting the officer's actions speak for themselves. Every step they take after an unlawful escalation is now under legal scrutiny. Your composure is not weakness. It is your most powerful legal tool. And this is where the practical part of this ruling matters most. If an officer conducted a search solely because you disclosed a legal firearm, this 920 decision gives your attorney significantly stronger footing. But you have to survive the roadside interaction first. You have to preserve your rights by exercising them correctly in the moment. So let us walk through exactly what that looks like. Picture the scenario. You are driving home. You are legally carrying. Everything is lawful. The lights come on behind you. The first thing you do when you stop is control your environment. Turn off the engine. Roll down your window. Place both hands visibly on the steering wheel. If it is dark outside, turn on your interior light. You want the officer to see immediately that you are not a threat. Officer safety concerns drive many roadside decisions. The more predictable and calm you appear, the lower the tension in that encounter. That matters more than most people realize. The officer approaches and asks for license and registration. Here is a mistake that ruins cases before they even start. Do not reach suddenly toward the glove box if your firearm is anywhere near the documents you need to retrieve. Instead, stay still and speak first. You calmly say, "Officer, my registration is in the glove box. I want to let you know I am legally carrying a firearm, and it is also in the glove box. How would you like me to proceed?" That single statement accomplishes three things at once. It shows cooperation. It shows awareness of the situation. and it dramatically reduces the uncertainty that causes traffic stops to escalate. Now, about disclosure. Some states legally require you to inform an officer immediately if you are carrying. Others do not. This ruling does not change those state-level requirements. Know your state law before you ever pull out of your driveway. If your state requires disclosure, comply calmly and clearly. If it does not require disclosure and the firearm is not visible, you are not legally obligated to volunteer that information unless you are asked directly. But if you are asked, never lie. Lying to an officer can turn a completely routine stop into a criminal situation faster than almost anything else. Then comes the moment that matters most. The officer says, "Do you mind if I search your vehicle?" This is where your constitutional knowledge either protects you or fails you, because consent changes everything. If you say yes, even casually, even just to seem cooperative, you have waived your Fourth Amendment protections in that moment. The Supreme Court's 9-0 ruling protects you from searches based solely on legal gun possession. It does not protect you from your own voluntary consent. So what do you say? You say, "Officer, I do not consent to any searches. That is it. No lecture, no hostility, no constitutional debate on the side of the road. Just calm, clear refusal. You are not required to explain your reasoning. And here is something critical to understand. Refusing consent does not create probable cause. An officer cannot legally say you refused. Therefore, I am searching anyway. Refusal is a protected exercise of your rights, not evidence of guilt. Now let us say the officer responds with the line you have probably heard before. "If you have nothing to hide, why not just let me look?" This is psychological pressure. It is designed to make you feel like refusal is suspicious. Do not take the bait. Stay steady. You respond calmly. "I respect your job, officer, but I do not consent to searches." And then you stop talking. Silence is more powerful than most people realize in these moments. Here is the mistake that destroys more Fourth Amendment cases than almost anything else: talking too much. After you have invoked your right to refuse consent, stop volunteering information. You are required to provide identifying documents. You are not required to answer investigative questions like, "Where are you coming from? Where are you headed? Or is there anything in the vehicle I should know about?" You can politely say, "I prefer not to answer additional questions." That is not disrespectful. It is completely lawful, and it protects your position. If a search happens anyway, and you believe it was unlawful, do not resist physically. Do not interfere. Instead, state clearly and calmly, "I do not consent to this search." Say it loud enough to be heard. That verbal record matters enormously in a courtroom later. Then, as soon as the stop is completely over, write down everything while it is fresh. The time, the location, the officer's name and badge number, exactly what was said, whether you consented or clearly refused, and what reason the officer gave for the search. Memory fades faster than people expect. Details are what win cases. Now let us talk about the bigger legal picture, because the geography of your rights matters too. The United States does not have one single uniform gun law framework. Every state has its own regulations governing concealed carry, open carry, reciprocity agreements, duty to inform requirements, and vehicle storage rules. If you cross state lines, your legal status can change the moment you cross that border. This Supreme Court decision strengthens your Fourth Amendment protections nationally, but it does not override valid state-level firearm regulations. If you are unknowingly violating a state carry law, even unintentionally, an officer who reasonably believes a violation is occurring may still establish probable cause. Ignorance of state-specific requirements is not a constitutional defense. That is why this ruling protects lawful possession, not mistaken possession. The shield only works when your carry is genuinely legal in the jurisdiction you are in, which means if you travel with a firearm, you need to research reciprocity and storage requirements for every state you pass through. That is not optional. That is part of being a responsible, protected gun owner. Here is the bottom line on everything we have covered. The Supreme Court just gave law-abiding gun owners one of the most significant constitutional wins in recent memory. They told the government clearly, "Excite. You can be a gun owner and still have a right to privacy. You can be armed and still be protected from unreasonable government intrusion." That is a profound and important affirmation. But constitutional strength does not replace personal responsibility. The ruling only works for people whose possession is lawful. It only protects you in the courtroom if you handled the roadside encounter correctly. It only becomes a shield if you did not hand the officer a sword by consenting to the search, making contradictory statements, or reaching unexpectedly. So here is what you carry with you from this point forward. Calm hands when you stop. Clear communication when the officer approaches. No sudden movements. No voluntary consent. No roadside constitutional debates. Know your state's carry laws. Understand reciprocity if you travel. Store firearms according to state requirements. Maintain valid permits where they are required. Because if your possession becomes unlawful for any reason, the protection this ruling provides disappears entirely. Most people will never hear a breakdown like this. Most gun owners will only learn about these constitutional boundaries after something has already gone wrong. After the search has happened, after the charges are filed, after the arrest has already been made, and after it is too late to go back and handle the stop the right way. You watched this. You paid attention. You put in the time to understand your rights before something went wrong. That means you are already ahead of the vast majority of people who carry a firearm every single day without any of this knowledge. Stay informed. Stay calm. Stay lawful. Because in this country, rights are strongest when the people who hold them understand exactly how to exercise them wisely. And the next time those lights flash in your rearview mirror, you will know exactly what to do and exactly what not to do. This is educational information about constitutional law. It is not legal advice for your specific situation. Laws vary by state, and the facts of every individual matter. If you face a legal issue, consult a qualified attorney who practices in your jurisdiction.